Hello class. Recall from the introduction of this course when I showed to you the sale or exchange of goods and the corresponding payment and the role of negotiable instruments as a substitute for money. Now we have here a law which covers the what they call documents of title. So a warehouse receipt is a form of document of title which is actually what is being issued by a warehouseman to evidence that the person in possession of the warehouse receipt is entitled to receive the goods being kept by a warehouseman. So a warehouse receipt is a form of, together with other relevant documents, is a document of title which covers the goods or mass of goods that are stored by a certain warehouseman. So we have this our warehouse receipt law enacted in 1912. So who issues a warehouse receipt? That would again be your warehouseman who is engaged in the business of storing goods for profit. So for our warehouse receipts law to be applicable, there must be a warehouse receipt issued by a warehouseman. The receipts should indicate the location of the warehouse where the goods are stored, date of issue of the receipt, a unique number of the receipt. So our warehouseman has a set of warehouse receipts with consecutive numbers. A statement whether the goods received will be delivered to the bearer or to a specified person or to a person or his order. Of course, the rate of storage charges for the revenue generating activity of the warehouseman. A good description of the goods or the packages containing them, and the signature of the warehouseman, which may be made by his authorized agent. If the receipt is issued for goods of which the warehouseman is owner, either solely or jointly or in common with others, the fact of such ownership. A statement of the amount in advances made and liabilities incurred in which the warehouseman claims as lien over the goods being stored or kept. Now, what happens if essential contents are omitted? The warehouseman shall be liable to any person injured thereby, as well as for all damages caused by the such omission. The validity of the receipt is not affected. The negotiability of the receipt is not affected. Terms that cannot be included in the warehouse receipt: any contrary to any provision of the law. Um, in any wise impair the warehouseman's obligation to exercise the degree of care in the safekeeping of the goods entrusted to him. Now we have both non-negotiable warehouse receipts and negotiable warehouse receipts. For non-negotiable, the goods received will be delivered to the depositor or to any specified person therein. So it's quite straightforward. But for negotiable warehouse receipts, receipt in which is stated that the goods will be delivered to the bearer or to the order of any person named in such receipt. No provision shall be inserted in a negotiable receipt that is non-negotiable. If inserted, those provisions shall be void. Now, there will be duplicate receipts. However, the word duplicate shall be plainly placed on the face of every such receipt, except the first one issued. So if you have triplicates, then you have the first page would have no label, but the subsequent copies, second and third, should have a label as duplicate. So our warehouseman shall be held liable for damages for failure to do so, because that would cause confusion with the holder of the original receipt. So what are the principal obligations of our warehouseman? Of course, to take care of the goods, to deliver them to the holder of the receipt or depositor provided the following conditions are met. So an offer to satisfy the warehouseman's lien, an offer to surrender the receipt, readiness and willingness to sign when the goods are delivered, and acknowledgement that they have been delivered if such signature is requested by the warehouseman. What should accompany the demand for the return of the goods? An offer to satisfy the warehouseman's lien, an offer to surrender the receipt, readiness and willingness to sign when the goods are delivered. So a warehouseman is justified in delivering the goods to one who gets to secure the goods from the warehouseman. That would be the person lawfully entitled to the possession of the goods or his agent. A person who either himself entitled to delivery by the terms of a non-negotiable receipt or has written authority from the person who is entitled. If it's a negotiable receipt, then the person in possession of by the terms of the goods are delivered to him or order or to bearer, or which has been endorsed to him or in blank by the person to whom delivery was promised. What if the warehouseman misdelivers? So if the warehouseman delivers to one who is not lawfully entitled to possession of the goods, he shall be liable for conversion or estafa, to all having the right of possession to the goods. And although he delivered the goods as authorized, he shall also be liable if prior to such delivery he had either been requested or on behalf of the person lawfully entitled to or should have possession of the goods did not make such delivery, had information to delivery about to be made, and was not lawfully entitled to the possession of the goods. So an emphasis on conversion or estafa. This is the unauthorized assumption and exercise of the right of ownership over goods belonging to another through alteration of their condition or exclusion of the owner's rights. Now again, for negotiable receipts, they must be cancelled or marked when goods are delivered or when part of it is delivered. So if the warehouseman fails to do so, he shall be made liable. So what would happen if there is alteration? If the alteration is immaterial, whether fraudulent or not, authorized or not, warehouseman is liable to the altered receipt according to its original tenor. But if the alteration is material, warehouseman is liable according to the terms of the receipt as altered. If the material alteration is innocently made, the warehouseman is liable on the altered receipt according to its original receipt. Excuse me. When it is fraudulently made, liable according to the original tenor of the receipt to a purchaser of receipt without notice, and even to the alter and subsequent purchasers with notice, except as regards to the last two, the warehouseman's liability is dependent only to delivery as he is excused from any liability. So note that even a fraudulent alteration cannot divest the title of the owner of goods of the stored goods, and the warehouseman is therefore liable to return them to the owner. But if the bona fide holder acquires no right to the goods under a negotiable receipt, which has been lost or stolen, or to which endorsement of the depositor has been forged. For lost or destroyed receipts, our courts may order the delivery of the goods upon satisfactory proof of such loss or destruction and upon giving of a bond with sufficient sureties to be approved by the court, and to protect the warehouseman from any liability or expense which he or any person injured by such a delivery may incur by reason of the original receipt remaining outstanding. The court also, in its discretion, order the payment of the warehouseman's reasonable cost and counsel fees. The order of the court shall not relieve the warehouseman from liability to a person to whom the negotiable receipt has been or shall be negotiated for value, without notice of the proceedings or the delivery of the goods. So you're similar to a holder in due course. If that person did not have notice that there were court proceedings already and that the court had already ordered the delivery of the goods because it was satisfied that there was loss or destruction of receipts, then the warehouseman has to become liable. As for the duplicates, the warehouseman warrants that the duplicate is an accurate copy of the original receipt, and that such original receipt is uncancelled as of the date of the issue of the duplicate. Our warehouseman cannot set up title in himself, so meaning he cannot refuse to deliver the goods on the ground that he has acquired title to a right to the possession of the goods, unless such title or right is derived directly from a transfer made by the depositor at the time of deposit for storage or subsequent thereto, or from our warehouseman's lien. Our warehouseman can file for an interpleader when there are adverse claimants. When we say adverse claimants, you have one person, more than one person claiming title to the same set of goods. So the warehouseman, to relieve himself of the dilemma, can file an interpleader in court. So our warehouseman has reasonable time to determine validity of claims. So if someone other than the depositor or person claiming under him has claim to title or possession of the goods, the warehouseman has information of such claim. He shall be excused from liability for refusing to deliver the goods to the person claiming under him or to the adverse claimant until he has had reasonable time to ascertain the validity of the adverse claim. This would mean that our warehouseman can bring legal proceedings to compel all claimants to interplead. Non-existence or misdescription of goods. Warehouseman is generally is under obligation to deliver identical property stored with him. So a warehouseman is stopped whether the receipt is negotiable or not to deny that he has received the goods described in it. Loss due to lack of care. So our warehouseman is required to exercise ordinary or reasonable care in the custody of the goods. So he is not liable for any loss or injury to the goods which could not have been avoided. despite the exercise of proper care. On the question of commingling of deposits of goods, the warehouseman is not supposed to commingle goods belonging to depositors. So he should have the proper labeling and uh, placement or boxing of goods accordingly. But in case of fungible goods, our warehouseman is allowed to mingle them when the goods are of the same kind and grade, and he is authorized by agreement or custom. So commingling is for the benefit of the warehouseman. Attachment or levy of a negotiable receipt. Okay, so our warehouseman has direct obligation to hold possession of the goods of the original owner. So while in possession of the such warehouseman, the goods cannot be attached or levied upon under an execution unless, so these are our exceptions, because the document is first surrendered, negotiation is enjoined, the document is impounded by the court. This shall not apply if the person depositing is not the owner of the goods or has no right to convey title to the goods binding upon the owner. Neither shall it apply to actions for recovery or manual delivery of goods by the real owner, nor in cases where the attachment is made before the issuance of a negotiable receipt of title. So, what are our creditors' remedies for them to reach a negotiable receipt? The creditor whose debtor owns a negotiable receipt needs the aid of the courts of appropriate jurisdiction by injunction or otherwise in attaching such receipt to satisfy that creditor's claim. As for our warehouseman's lien, what are the claims included? So, all lawful charges for storage and preservation of the goods. So, if the goods needs uh, freezing, then the cost to freeze the goods can be charged or can be claimed by our warehouseman. If there are advanced money, so interest, insurance, transportation, labor, weighing, cooperating, and other charges and expenses. All reasonable charges and expenses for notices and advertisements of sale. Sale of goods where default has been made in satisfying the warehouseman's lien. Against what property may the lien be enforced? Against all goods, whether deposited, belonging to the person who is liable to the debtor for claims in regard to the lien in which the lien is asserted. Against all goods deposited by the person who is liable. When does our warehouseman lose his lien? By surrendering possession thereof, by refusing to deliver the goods when demand is made and that he is bound to comply with the delivery. Lien where receipt is negotiable, with the exception of charges for the storage and preservation of the goods, for which negotiable receipt has been issued. Lien exists only for other charges expressly enumerated in the receipt. Other days in connection to the warehouseman's lien need not deliver the lien is warehouseman need not deliver lien is satisfied. Warehouseman lien doesn't preclude other remedies. If our warehouseman has other remedies, then he can go after those other remedies. So our warehouseman can satisfy his lien by sale upon giving written notice to the person whose accounts the goods are held, and any other person who has claim or has interest on the goods. Our notice shall contain an itemized statement of the claim showing the sum due and the time the notice and the dates when it has become due, a description of the goods, and a demand that such amount of claim as stated shall be paid on or before the days mentioned. A statement that unless the claim is paid, the goods will be advertised for sale, sold by auction at a specified time and place. So how does our warehouseman enforce his lien? By refusing to deliver the goods until the lien is satisfied, or by causing an extrajudicial sale. And finally, by filing a civil action for collection for the unpaid charges. What happens if our warehouseman sells our goods? The warehouseman is not liable for non-delivery. The sale was made without publication requirement before the time specified by law. Such sale is void. When is our warehouseman liable? Of course, failure to stamp duplicate on copies of the negotiable receipt, failure to place non-negotiable or not negotiable for non-negotiable receipts, misdelivery of goods, failure to effect cancellation of a negotiable receipt upon delivery of the goods, issuing a receipt for non-existing goods or misdescribed goods, failure to take care of the goods, failure to give notice in case of sale of goods to satisfy a lien or because goods are perishable or hazardous. So negotiation and transfer of receipts, negotiation of negotiable receipt by delivery, where the terms of the receipt the warehouseman undertakes to deliver the goods to bearer, not to the order of someone but to bearer. Well, where by the terms of the receipt the warehouseman undertakes to deliver the goods to the order of a specified person, and subsequently that person endorses the receipt in blank or to bearer, basically converting the order instrument into a bearer instrument. Where the terms of the receipt, the goods are deliverable to bearer, and where the negotiable receipt has been endorsed in blank or bearer. The negotiation of negotiable receipt by endorsement. So, endorsement in blank or to bearer, and again, to a specified person who subsequently endorses it in blank or to bearer. How about non-negotiable receipts? These cannot be negotiated, but they can be transferred or assigned by delivery. The assignee or transferee only acquires the rights of the transferor or assignor. So if that's the case, why would you want a negotiable warehouse receipt? Because it protects a purchaser for value and in good faith. The defenses or the rights that a holder in due course gets to enjoy. The goods covered by the receipt cannot be garnished or levied upon under execution unless it is surrendered, impounded, or its negotiation enjoined. In case of negotiation, holder acquires the direct obligation of the warehouseman to hold possession of the goods for him without notice to such warehouseman. The goods it covers are subject to seller's lien or stoppage in transitu. Who may negotiate a receipt? Oh, our owner, a person, any person to whom possession or custody of receipt has been entrusted by the owner. And at the same time, those that are negotiated by delivery. So persons who to whom the receipts has been negotiated can have the right to the title of the person negotiating the receipt and title the person to whose order, by terms of the receipt, the goods were to be delivered as such, and of course, the direct obligation of the warehouseman to hold and possess the goods for him. But if the receipt was merely transferred, then he gets title to the goods as against the transferor, right to notify the warehouseman of the transfer, and right to acquire the obligation of the warehouseman to hold the goods for him. Rights over transferee, a right to the goods as against the transferor, right to compel the transferor to endorse the receipt. Rules when receipt is subsequently endorsed for the purpose of determining whether the transferee is a purchaser for value in good faith without notice. The negotiation shall take effect as of the time the endorsement is actually made and not the time the receipt was delivered. Reason, the negotiation becomes complete only as of the time of endorsement. What are the warranties? That the receipt is genuine, that there is legal right, that he has knowledge of no fact which would impair the validity of the worth of the receipt, that is right to transfer the title of the goods, and that the goods are merchantable and fit for a particular purpose. Our endorser is not a guarantor. So, endorsement of receipt does not make the endorser liable for any failure on the part of the warehouseman or previous endorser of the receipt to fulfill their respective obligations. No warranty implied from accepting payment of a debt. So, a mortgagee, pledgee, or holder of a security of a receipt who in good faith demands or receives payment of the debt for which such receipt is security, whether from a party to a draft drawn or for such debt or other person shall not by so doing be deemed to represent or to warrant the genuineness of such receipt or to the quantity and quality of the goods therein described. So the holder of a securities in good faith accepts payment of a debt from a person doesn't warrant thereby the genuineness of the receipt or the quality and quantity of the goods. When negotiation is not impaired by fraud, duress, or mistake, okay, the validity of the negotiation receipt isn't impaired by the fact that such negotiation was a breach of duty on the part of the person making the negotiation, or by the fact that the owner of the receipt was induced by fraud, mistake, or duress to entrust the possession of the custody of the receipt to such person. If the person to whom the receipt was negotiated or to the person of the receipt is subsequently negotiated paid value, therefore. So he paid value, so a holder for value, without notice of breach of duty, fraud, mistake, or duress. So similar to a holder in due course. When there is subsequent negotiation by seller, so the purchaser, mortgagee, or pledgee of goods for which negotiable receipts has been issued, or of the negotiable receipt itself, has the duty to require the negotiation of the receipt to him. If he fails to do so, this will have the same effect as an express authorization on his part to the seller, mortgagor, or pledgor in possession of such receipt to make subsequent negotiations. So it's very important to require the negotiation of the receipt to him. The subsequent purchaser must have taken the receipt in good faith and for value in order to acquire a better right. So the endorser's right is superior to a vendor's lien. So an innocent holder of a negotiable receipt, take note, negotiable receipt, has better right to the goods for which the receipt is given than the vendor who has vendor's lien upon such goods. So our warehouseman isn't obliged to deliver or is justified in delivering the goods to an unpaid seller unless the receipt is first surrendered for cancellation. So if the vendor does not have the original receipt, negotiable receipt with him, that vendor cannot uh, enforce the delivery from the warehouseman. How do you attach or impose a lien over goods covered by a warehouse receipt? If it is not negotiable, the court would issue a writ of attachment. However, if it is negotiable, the court should require the surrender of the receipt and restrict further negotiations.